Welcome, everybody. Welcome to the members of this committee. Before we get to the substance of the hearing, I want to take just a few minutes to discuss the empty table before us. It's a symbol for how little regard the Obama administration seems to have for the American people. 2 weeks ago, this committee sent a letter to 3 current employees of the U.S. Treasury Department requesting their attendance here at this hearing to talk about Treasury's role in developing the Obamacare exchange's subsidy rule, which is hurting millions of people across this country and which is directly contrary to the statutory text of the underlying bill. Specifically, this committee sent letters to Mark Mazur, who's Assistant Secretary for Tax Policy at Treasury, to Emily McMahon, who's the Deputy Assistant Secretary for Tax Policy at Treasury, and who was serving as the Acting Assistant Secretary for Tax Policy when the rule was written and finalized, and to Cameron Atherton, who is the Deputy Tax Legislative Counsel for Tax Policy at Treasury. Shortly after these invitation letters were sent, the Treasury Department reached out to my staff and brazenly indicated they did not intend to send any witnesses. You know, I would note our former Attorney General, Eric Holder, the first Attorney General in the history of this country to be held in contempt of Congress. These 3 empty seats demonstrate the ongoing contempt for Congress and for the American people that is manifested by the Obama administration. For the Treasury Department to tell the United States Senate they have no time, they will not even answer questions about how they promulgated rulemaking in direct conflict with statutory text is the height of arrogance. The beginning of this hearing was to give them an opportunity to come and answer questions, to recognize the oversight responsibility given to the Senate, given to Congress by the United States Constitution. By their absence, I take it, the administration is saying they are not subject to oversight. And yet, at the end of the day, the American people provide the ultimate oversight. Given that the administration refused to cooperate in this hearing, it is my hope that the full committee will take it to the next level of invoking compulsory process so that members of the executive branch will be made to answer whether they tried to follow the law or whether they were instructed by political operatives to disregard the law in the interest of a political outcome. That's a question the executive needs to answer. And the purpose of this hearing is to begin getting to the bottom of it. Now, I can understand why the administration is reluctant to engage in this discussion. I can understand why, both in substance, after over 5 years of Obamacare, we have seen that millions of people are hurting under it. The American people were promised by the president, if you like your health insurance plan, you can keep your health insurance plan. Well, millions of people discovered that promise was false, that it was knowingly, deliberately false, as millions of Americans had their health insurance plans canceled. The president promised the American people, if you like your doctor, you can keep your doctor. That, too, we now know, was a statement that was knowingly, deliberately false. Today, as a consequence of Obamacare, millions of Americans have lost their jobs, have been forced into part-time work, have lost their health insurance, have lost their doctors, and are facing skyrocketing insurance premiums. So I can understand why the administration would be reluctant to defend that record on the merits. I can also understand why the administration does not want to answer questions about the underlying legal question. The statutory text is straightforward. And at the end of the day, it is not a complicated question. What the administration did is took statutory language of an exchange established by a state, and through transmogrification that would make Harry Houdini shake his head in wonderment, defined the federal government's exchange as an exchange established by a state. The question this hearing and the next panel hopefully will get to is, was that an attempt by an executive agency to follow the law, to carry out the president's constitutional obligation to take care that the laws be faithfully executed? Or was it instead a deliberate effort to ignore the law, driven by political and partisan objectives from political appointees at the Treasury Department and the White House? This is a question of exceptional importance, because if the executive refuses to implement the laws that are passed by Congress, then the basic protections of our Constitution become ephemeral. That's the purpose of this hearing. I'm disappointed that the administration has chosen not even to engage in this conversation. With that, I'll recognize the ranking member, Senator Cruz.
Thank you, Senator Cruz. I thought I would open by commenting that in this very same room earlier today, we had a lengthy 3-hour markup of the Senate Judiciary Committee on distinct but important issue, patent litigation reform. And at the conclusion of his remarks, I was compelled to whisper to my staff counsel that I thought Senator Cruz on that topic got it exactly right. I will not be saying the same thing.
I hope that comment is not used against you in your next campaign.
Hopefully it will not.
I hope it's not used against you in your campaign.
I just mentioned that at the outset by way of saying that while we may have found agreement on some important issues of the protection of a constitutionally protected property right this morning, we will approach, I think, today's discussion and this hearing with a somewhat different perspective. I find it unremarkable that the witnesses requested for today did not appear. The administration has ongoing litigation before the Supreme Court, which is expected to be resolved very soon. And it's my understanding that they were not comfortable sending a witness to this hearing under those circumstances, and I find that unremarkable. Congress has a way of compelling cooperation with oversight, which it has not done. So the simple fact is we are left with a so-called hearing today about the rulemaking process in a Senate Judiciary Subcommittee with witnesses who are not in any way involved in the rulemaking process. It is my hope that we will move past this political theater and on or back to the substance of the Judiciary Committee. Thank you.
All right, we'll go ahead and give each senator who's here a chance to make a brief opening statement before we move on to the next panel. And the senator on this side of the aisle who was here next was Senator Sessions.
Thank you, Mr. Chairman. As a longtime practitioner in federal court, 15 years really practicing before federal judges, I developed such a great respect for those men and women who lead those courts, the judicial process that we go through, the legal process that we go through. And in Alabama and states all over the nation, we presume laws are passed. Juries are told that the executive enforces the laws, and the people expect that. That's the whole essence of the American legal system. And the President of the United States is, in fact, the chief law enforcement officer in America. He has an absolute duty to see that laws are faithfully executed. And I've seen in my time here, presidents of both parties acquiescing in the policies they don't like because the law was to the contrary. And we have, to a degree, I don't believe we've ever seen a president of the United States who is so willing to just ignore plain law to advance a political agenda. This threatens law in America. American people acquiesce in court decisions every day, many of which they strongly disagree with, but they acquiesce because that's our system. But part of their acquiescence is a grudging belief that somewhere somebody is following through on legal procedures, and what's happening to them in the courtroom is a result of some sort of fair and decent process. And I do believe, Senator Cruz, that we're not in a healthy relationship right now. And if we get to the point where the American people believe that the Supreme Court, 5 members out of 9 of the Supreme Court, are just advocating and imposing their views instead of faithfully following classical interpretive policies of law, then I think we have threatened the foundation of this republic. My full and firm belief is that the strength of this republic is founded on the Anglo-American rule of law, which we basically inherited. We just celebrated the 800th anniversary of Magna Carta, and that's different from a lot of people. So, Mr. Chairman, thank you for having this hearing, and I don't believe the president is entitled to do what he wants to, no matter what the law says.
Thank you, Senator Sessions. Senator Blumenthal.
Thank you, Mr. Chairman, and I want to join with my colleague, Senator Coons, in expressing my appreciation for your very eloquent remarks this morning, even though we voted on opposite sides of the issue, and for your having this hearing, because I think it's a topic that well merits attention and scrutiny. If I had been asked for my advice by these witnesses, and I wasn't, I would have probably given them counsel that appearing here to talk about these issues literally on the eve, or perhaps a few days before the United States Supreme Court rules on almost directly related questions of law and possibly fact, would have been imprudent and even foolhardy, and might have been perceived as improper. The timing of this hearing in relation to the United States Supreme Court decision predetermined the outcome of their appearing here. And I would respectfully suggest, Mr. Chairman, that these same witnesses be invited at some later point. Certainly, consideration by the full Judiciary Committee of any compulsory process should await another invitation at a different time. And I do not mean to suggest that the empty table was used as a prop for an argument that may be misperceived, but I would strongly urge that this committee revisit the potential testimony from these witnesses on another occasion. On the issue at hand, contrary to the arguments of many partisan opponents, I firmly believe that the right decision will be to uphold this law. Both the act itself and plainly overwhelming evidence from its consideration and passage demonstrate its nationwide scope. Everybody involved understood when it was being debated and when it was being passed that tax credit would be available regardless of which government entity set up an exchange. The act simply would not have worked any other way. The financial support for universal coverage would not have been there without this understanding. And so I welcome the scrutiny and oversight and hope that we will find a path where we can really, on a very bipartisan basis, work together. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Hatch.
Well, thank you, Mr. Chairman. Let me begin by thanking the chairman for convening what I consider to be an important hearing. And I'd also like to say I'm very disappointed by the first panel's decision not to appear here today and testify. Here we are investigating a hugely important issue, whether Obamacare authorizes subsidies for health care plans purchased through the federal exchanges, and the administration's representatives won't even talk to us. You would think the administration would jump at this opportunity to tell the public how it determined that the text of Obamacare means the exact opposite of what it says. How it determined that established by state means established by the federal government. I can only conclude that the administration's refusal to participate today means it has no really good explanation. It decided early on that subsidies needed to be available on federal exchanges if the law was to work the way the president envisioned, and didn't particularly care what the statute actually said. So many things about this whole process are disturbing. You have a Congress that passes a hugely consequential bill through a backwards legislative process after the people of Massachusetts elect a Republican senator to stop the bill from moving forward. You have a president that then decides to rewrite the law through administrative fiat so that it says what he wishes it said rather than what Congress actually wrote. And now you have a senior administration officials refusing to even show up to explain how they arrived at their anti-textual reading of the statute. Now, these are not the actions of an executive branch accountable to the rule of law. These are the actions of an executive branch willing to bend the law to suit political purposes. I've spoken many times about President Obama's disturbing disregard for the rule of law, of which the Obamacare subsidy rule is just one example. Last month, I published an article with the UCLA Law Review explaining how the president's rewriting of Obamacare contravenes important constitutional checks on his authority. The article is entitled King versus Burwell and the Rule of Law, after the court case challenging the president's action. I'd like to just quote from that article. Quote, "What's ultimately at stake here is the president's obligation to follow the law. Faced with a statute that doesn't operate quite the way he envisioned, President Obama decided to disregard the parts of the law he doesn't like and instead implement a different statute. But the Constitution doesn't give the president leave to unilaterally rewrite laws. The power to amend laws lies with Congress, and until Congress amends a statute, the president is bound to the text Congress passed," unquote. Now, I ask unanimous consent that the article be entered into the record. And
Without objection.
I'm glad we have a second panel with us today who can talk about the administration's path to determining that subsidies can be offered on federally established exchanges, even though Obamacare provides no such authority. Now, I wish the administration would take this as seriously as we do. And let me just say that I lived through that whole Obamacare matter and heard all sides and really got tremendously involved in it, naturally, because I've done an awful lot of health care legislation over my 39 years in the Congress. And I have to say that one of the principal arguments was, by some, that the people would have to go, the exchanges would have to be set up by the state. And the argument behind it was, that's the only way you're going to get people to really sign up for it, because that's where the money goes. And that argument was used on more than one occasion. And all I can say is I'm very concerned about this whole issue. The statute is unambiguous. It's amazing to me that we've come this far without somebody admitting that, hey, they made a mistake, and that we would have to rewrite the law so that you can do what they've just unilaterally decided to do without any real legal authority to do it. Thank you, Mr. Chairman.
Thank you, Senator Hatch. Senator Whitehouse.
Thank you, Chairman. I want to echo the comments of my colleagues about the empty chairs here. Senator Blumenthal and I have both been the attorneys general of our states, and we have had the obligation to provide advice to government officials on how to respond when their agency is the subject of ongoing litigation. And I concur fully with the remarks of Senator Blumenthal, and I concur fully with his recommendation that once that impediment is lifted, the chairman should consider having the witnesses return. I think it could be a constructive hearing if it were not for that impediment, which I think is a real and genuine one. In Rhode Island, we aren't very affected by King v. Burwell because we did set up a state exchange. And our state exchange has been quite a success. We've just hit 500 businesses having achieved health care through our exchange, which has a business plan as well as the individual plan. Thousands of families have achieved coverage. Our major primary care practice groups are adapting the way in which they practice to take advantage of some of the innovation programs in the Affordable Care Act. They are seeing better care for their patients. Their patients are seeing longer hours, simpler processes, more support for prevention and other types of less costly ways of dealing with people's health. So we're seeing really better care delivered in a less costly way that is simpler and clearer, less bedeviled by the confusion and duplication that had been the hallmark of our healthcare system. We're seeing that at the national level through the savings. The Pioneer ACOs have just been put through the Innovation Center as an approved nationwide process because they were able to demonstrate to the actuary hundreds of millions of dollars in savings, all accompanied by better, simpler care for the individuals whom they serve. So I think we have a continuing process that we're obliged to pursue to make sure that the American healthcare system, which remains by 30 to 50% more expensive per capita than all of the countries that we compete with, the other industrialized countries. And I think that gives us an obligation to really try to keep our eye on the ball and to make sure that we're reducing the cost of care while maintaining or actually likely even improving the quality of care that our people receive. There's absolutely no reason that we should continue to be the country that has the highest per capita costs in the developed world and yet has healthcare outcomes as measured by things like length of life that equate to countries like Greece and Croatia. We can do a lot better. The Affordable Care Act is a tool that is already being proven to do a lot better. And in my view, the exchanges are a tool for continuing to drive the healthcare system in that direction, away from duplication, away from fee-for-service, away from confusion. Unfortunately, behind the political language and the political fights that have accompanied the Affordable Care Act, there are just an awful lot of Americans who, particularly those who've had a loved one or who have themselves had a very serious illness and who've had to deal with the American healthcare system, and they've seen firsthand what a complex, burdensome, inefficient, bedeviling system it was. And I think that particularly in this area of lowering costs by improving the quality of care, the Affordable Care Act has really made some important breakthroughs. We want to encourage those breakthroughs to make us more internationally competitive and to provide a better humane result, frankly, for the people of the country. And at least in Rhode Island, I think the state exchange is helping our state manage that problem and steer itself in that direction. So thank you very much for the time, and with my time expiring, I'll yield back.
Thank you, Senator Whitehouse. I'll make a couple of observations and then we'll welcome the second panel. One, when it comes to discussions of cost and limiting health care and health insurance cost, I think on the merits, Obamacare has been an abject failure. President Obama promised the American people, if this law passed, that the average family would see a $2,500 decrease in health insurance premiums. I think you will be hard-pressed to find many families for whom that is the case. Indeed, the average family in America under Obamacare has not seen any health insurance premium decrease. Rather, the average health insurance premium increase has been over $3,000. That's $5,500 difference out of hardworking Americans who are struggling to pay the bills. And they're discovering that under Obamacare, they're getting less coverage for that. They have higher deductibles, they have higher copays, they have less coverage, and they're paying more. I would also note that the administration's justification for not being here is the pendency of King versus Burwell. And yet, Ms. McMahon, one of the three witnesses who was called here today, testified before the House Oversight Committee on July 31st, 2013, while the Halbig case with the same underlying issue was pending. The record was open in that case, and yet the administration sent a witness. And yet here they're unwilling to answer those same questions about whether the administration is willing to comply with the law. The letter this committee sent to Treasury Secretary Jack Lew on May 27th, without objection, I'm going to enter that letter into the record, and I'll hold the record open for a week for any additional material senators would wish to enter. With that, I'd like to welcome the second panel to the table, and we'll start immediately as soon as you can be seated. I'd like to introduce briefly the members of the panel. We have Mr. Michael Carvin. He's a partner at Jones Day. He is the lead lawyer in King versus Burwell, and he has the ignominious distinction of being my very first boss in private practice, which I'm sure many will hold him to account for all of the mistakes I've made since then. We've got Mr. Michael Cannon, who is the Director of Health Policy Studies at the Cato Institute. He is a learned and well-respected scholar on questions of economics and healthcare. We have Professor Andy Graywall, who is an associate professor of law at the University of Iowa College of Law in Iowa City. We have Ms. Elizabeth B. Wydra, who is the chief counsel of the Constitutional Accountability Center here in Washington, D.C. And we have Mr. Robert Weiner, who is a partner at Arnold & Porter. I'd like to ask each of the witnesses to stand and be sworn in, please. Will you raise your right hand? Do you affirm that the testimony you are about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you very much. Mr. Carvin, we'll start with you. Please turn your microphone on.
Is it on now? Thank you. I was just talking about the importance of this hearing, as a number of senators have already indicated. While the policy issues here are obviously very important, I think the real issue for this hearing is the rule of law. Is this going to be a nation governed by laws enacted by this body pursuant to constitutional prerogatives, or is it going to be governed by the policy preferences of unelected bureaucrats? And I think that that's exactly what happened in this case. I think this is an extraordinarily simple case, and I think the IRS has not interpreted the law, but very dramatically revised the law. And that's because the law simply says that you receive subsidies on exchanges established by the state under Section 1311, and the IRS has transformed that into something that where you receive subsidies on exchanges established by HHS under 1321. And anyone who speaks English knows that that's not a reasonable interpretation of that language. The proponents of the IRS rule have argued they can't dispute that the plain language commands the opposite of what the rule says, so they try and change the subject. They say, well, you've ripped that language out of context, and that language is contrary to the underlying purpose of the statute. But in reality, neither of those is true. In fact, the context in which those words reside confirms in every way that the plain language means exactly what it says, and following that plain language is really the only way to implement the broader purposes of the Affordable Care Act. For example, in terms of context, it's argued that this is an unusual place to put a restriction on subsidies, but the reality is that Section 36B is the only provision in the Act that deals with the availability of subsidies, and the reality is that it's the only restriction, for example, that makes it clear that you need to make a purchase off of an exchange in order to receive the subsidies. So far from being an unusual place to put the restriction in the statute, it's the only logical place, and context makes that clear. In terms of the statute's broader purposes, the plain text of Section 1311 of the Act makes it clear that a principal purpose of the Act is to ensure that states run these exchanges and not the federal government. Indeed, it's stated in the mandatory, the states shall establish and operate these exchanges. And one of the principal problems with the IRS rule is it dramatically undermines that statutorily stated purpose. Since the IRS rule makes the subsidies available regardless of whether states have established an exchange, it provides the states no incentives to undertake this difficult and arduous task. So the IRS rule dramatically undermines one of the stated purposes of the ACA, which is to have states establish the exchanges. None of the proponents of the rule can explain why any reasonable person, reasonable legislature would have thought all the states or most of the states would have done this if they were provided no incentive to do so, and they can't explain any incentive other than conditioning the subsidies. The notion that there's some purpose out there to have subsidies in all states is simply a fiction invented by the Obama administration. There's no text, there's no legislative history anywhere suggesting that Congress intended to make subsidies available on exchanges that are established by HHS. Therefore, the purpose argument is not any effort to discern congressional intent through any of the normal means of expressing legislative intent. It is actually a unilateral effort to impose the executive branch's own purposes in contradistinction to those of the legislature. We have a specific statutory provision that tells you what the limitation is in 36B. We have a specific statutory provision, Section 1311, that tells you why they impose that limitation, and there is no legislative history which contradicts either of those statutorily enacted texts. So any legislative material that any justice on the Supreme Court has looked at, there is no purpose that would justify the IRS's revision of the code. I think my final point I'll make is that the proponents of the Act can't even agree on the rationale behind why the IRS's revision was okay. The Solicitor General invented this term of art theory in the Supreme Court. You won't see that term of art theory anywhere in the IRS's discussion of the rule at the time they did it. So this was a post hoc invention by the Solicitor General that's not even consistent with what the IRS came up with. The media explanation for all of this was a giant mistake that nobody really understood what was going on, but neither the Solicitor General nor the IRS has bought into this notion that this was simply a matter of oversight. So all of the various rationales that have been offered up for this bureaucratic revision of the statute's plain text are not only unpersuasive, they're actually at odds with each other. Thank you.
Thank you, Mr. Carvin. Mr. Cannon.
Thank you, Chairman Cruz. Thank you, Mr. Chairman, Ranking Member Coons, and members of the committee for the opportunity to discuss what we do know about how the IRS developed its health insurance premium tax credit rule of May 23rd, 2012. That's the rule that's being challenged in King v. Burwell, and it's the rule that implements the premium assistance tax credit provisions of the Patient Protection and Affordable Care Act of 2012. Two federal courts have found that that rule expanded the reach of the ACA's employer mandate beyond the clear limits Congress imposed on the IRS's authority. According to those courts, the IRS is unlawfully subjecting more than 250,000 employers and 57 million workers to that tax. One of those workers is Kevin Pace, a jazz musician who lives not far from here in Northern Virginia. According to the Washington Post, Pace lost $8,000 of income in the first year the IRS unlawfully imposed that mandate on his employer as a direct result of the imposition of that mandate. According to one estimate, this illegal tax reduces a typical affected worker's income by nearly $1,000 and has eliminated nearly 250,000 jobs. Those federal courts likewise found the IRS's tax credit rule unlawfully expanded the reach of the ACA's individual mandate. As a result, the IRS is currently subjecting an estimated 11 million taxpayers to an illegal tax averaging $1,200 each. Whatever good the IRS hopes to accomplish with the funds raised by these taxes is irrelevant. The authority to levy taxes and to spend federal dollars rests with Congress alone. In King v. Burwell, 4 Virginia taxpayers alleged that this tax credit rule is subjecting them, Kevin Pace, and 57 million other Americans to illegal taxes. The Supreme Court has heard oral arguments in March and will likely rule later this month. A ruling for the challengers would invalidate that rule. It would create an estimated 237,000 new jobs, free more than 57 million Americans from illegal taxes, and increase affected workers' earnings by nearly $1,000. Now, my co-author, Jonathan Adler, and I have written at length about how neither the ACA nor the legislative history provide any support for the IRS's interpretation of the statute. Indeed, both the legislative history and the statute squarely foreclose the IRS's interpretation. But today, for the remainder of my testimony, I'd like to discuss the troubling picture that emerges from what little we know about how the IRS developed this rule and why we know so little about how the IRS developed this rule. The available evidence suggests that IRS officials recognized that the ACA did not give them the authority to impose these taxes, yet they imposed these taxes anyway. Treasury and IRS officials performed little or no analysis of the ACA and its legislative history. They used legislation that was rejected by Congress in order to support their theory of congressional intent, and they failed to consider important dimensions of this issue. The IRS's proposal to implement these taxes and subsidies in federal exchange states met immediate and sustained criticism, including from some members of this committee as far back as 2011. The administrative record offers no support or substantive explanation, no statutory support or substantive explanation of the IRS's decision to ignore the plain meaning of the tax credit eligibility requirement that recipients must enroll in health insurance through an exchange established by the state. The administrative record contradicts arguments the government offered before the Supreme Court and reveals those arguments to be post hoc rationalizations. Mr. Carvin mentioned the term of art argument that the Solicitor General made before the Supreme Court. What little we know about the administrative record shows that the IRS shows dispositively that the IRS did not believe that this was a term of art. The IRS has attempted to hide its actions and its reasoning from congressional scrutiny. According to an article in the Washington Post, which interviewed several officials at the Treasury Department and IRS who are involved in the development of this rule, one former official said, quote, "The overriding concern was not generating negative news stories." The overriding concern of the officials who wrote this rule was not fealty to the law, but avoiding negative news stories. And the IRS continues to try to avoid scrutiny. In December of 2011, the then-ranking member of the Senate Finance Committee, a member of this committee who's here today, Senator Hatch, sent a letter to the Department of the Treasury after the promulgation of this proposed rule and before it was finalized, disputing the legality of the rule and asking the Treasury Department to turn over all documents related to the development of this rule and the IRS's reasoning behind this rule. The IRS and the Treasury Department have been ignoring that request for 3.5 years. The IRS is taxing and spending the American people's money without permission from or accountability to Congress. The American people need to know how this happened, and that begins with transparency. I thank you very much for your time, and I look forward to your questions.
Thank you, Mr. Cannon. Professor Grewal.
Thank you very much, Mr. Chairman. I suspect that if the IRS had shown up today, it would tell you that it tried to carefully obey its statutory authority when it issued regulations under Section 36B. I want to explain why that's nearly impossible to believe. At the outset, I'll say I don't take any particular position on the King v. Burwell issue, and I don't know whether Obamacare is a good idea or a bad idea. So that's why I'm sitting here in the middle. But I do want to discuss 3 circumstances where other regulations under 36B clearly contradict the legislative language. And if you think established by the state is clear, you'll think these ones are very clear. I've even offered a case of beer on Twitter to anybody who could just come up with some colorable counterargument. In the first circumstance, the statute plainly grants credits only to citizens when their income falls within a particular range, 100% to 400% of the relevant poverty line amount. The IRS doesn't like that result, and it has potentially expanded credits to several million persons below the 100% amount. Again, if you think established by the state is clear, a statute that refers to 100% to 400% is far clearer. In the second circumstances, the ACA has two related provisions. One provision says that if you're a large employer and you offer health insurance to your employees, we want you to automatically enroll all those employees in coverage. And the Department of Regulations will issue regulations saying as much. If you're going to have a plan, get everybody in there. As a sweetener to this, the persons who are enrolled won't get credits under Section 36B because they're going to be getting coverage under the employer plan. With no credits, that means there's no penalties on employers when they automatically enroll employees in their existing plan. The IRS does not like that result, and it has issued a regulation saying that in some circumstances, you will actually get a credit under Section 36B, even though you are getting coverage by your employer, and the employer will relatedly get hit with the penalty. The third category I want to discuss relates to unlawful aliens. Congress recognized that some very low-income persons who are here lawfully can't get Medicaid. Some states say, well, all right, you're not a citizen, but we'll help you, but please wait 5 years before you apply for Medicaid. The statute, Section 36B, says that, okay, we'll help you out with credits on the on the state exchanges and arguably the federal exchanges. If you are here lawfully, you yourself can get a credit for policies purchased on an exchange. The Treasury has issued a regulation saying that even if you are here unlawfully and you meet the income requirements, you are eligible for a credit. Again, the statute is very clear that says that you must be here lawfully to get this benefit of this special rule. All of these three provisions may be good ideas in the abstract. I don't know. They seem reasonable on one level, but they clearly violate the relevant statutory language. In closing, I just want to emphasize that as we talk about the Treasury expanding Section 36B, we don't give enough attention to the fact that an expansion of 36B means more penalties from employers. Unlawful credits lead to unlawful penalty collections. And the fact that the IRS in expanding Section 36B is illegally collecting penalties from private businesses should receive more attention. Thank you, Mr. Chairman.
Thank you, Professor. Ms. Wydra.
Thank you, Chairman Cruz, Ranking Member Coons, and the members of the subcommittee for inviting me here to testify before you today. I must take issue, I'm afraid, however, with the substantive premise of today's hearing, at least as reflected in its title, which suggests that the Treasury Department rewrote the Affordable Care Act when it ensured that tax credits would be available nationwide to all Americans who need them. Far from rewriting the statute, I would assert that the Treasury Department applied the ACA according to its text, statute, design, and purpose when it interpreted the act and made this rule. Similarly, I must take issue, I'm afraid, with my esteemed colleague, Mr. Carvin. What you just heard him describe a few moments ago is not how statutory interpretation works. How you heard him describe the Affordable Care Act is also not how anyone who is involved with enacting the statute understood that law to work. Republican and Democratic members and staffers alike involved in drafting the law have made clear that no one understood the law to preclude tax credits for residents of states that opted to use the federal fallback provided to them in the law instead of electing to set up an exchange for themselves. To the contrary, statements by members of Congress at the time and reports drafted by committees and the CBO all assumed that tax credits would be available in every state on any exchange without making a distinction between state-run and federally facilitated exchanges. Did any members of Congress stand up at that time and profess the vision of the tax credit provision that we heard Mr. Carvin and other critics of the Treasury rule put forth? As Mr. Carvin had to admit when the Supreme Court asked him this very question, there were none. But I'd like to back up for a moment to talk about the language of the statute itself, because I think it's important to correct what I see as some mischaracterizations. As Justice Scalia reiterated last year, it is a fundamental canon of statutory construction that the words of a statute must be read in their context and with a view to their place in the overall statutory scheme. In other words, not plucking a four-word phrase out of a statute and using it to defeat the very fundamental purpose of the entire act, which in this case was to provide affordable health insurance for all Americans. To help achieve this aim of broadening access to health care and insurance, the statute provides for the establishment of exchanges on which individuals can purchase quality affordable health insurance. Section 1311 provides that, quote, each state shall, not later than January 1st, 2014, establish an American health benefit exchange. The act clarifies, however, that there is, quote, state flexibility in meeting this requirement. A state may elect to set up the exchange for itself, or if a state chooses not to establish an exchange or cannot establish an exchange that meets the Act's requirements, then HHS, according to the statute, shall establish and operate such exchange within the state. When the statute then uses the term an exchange established by the state in the statute, it refers to exchanges established at the state level by the state, as well as exchanges established at the state level by HHS standing in the shoes of the state. Now, with respect to the eligibility for tax credits allowing individuals to afford to purchase insurance on these exchanges, the Act expressly presents income level as the method by which an individual is determined to be eligible or not for these tax credits, not the bureaucratic entity which runs the health insurance exchange in that state. But what about the phrase seized upon by critics of the Treasury Department's rule found in the provision for calculating the amount of the tax credit who purchased a policy on an exchange established by the state? Well, you could pluck a four-word phrase out of Moby Dick and say that it was a story about a Sunday whale-watching cruise, but that's not how you read a book, and that's not how the Supreme Court tells us you read a statute either. Reading the law to provide tax credits nationwide on both state-run and federally facilitated exchanges allows the provisions of the ACA to work harmoniously, which is something the Supreme Court has told us clearly is something that should be a guidepost when we're reading statutes. In contrast, the reading asserted by the King challengers would deny effect to the regulatory scheme by subverting the Act's structure and design and basic purpose and rendering important provisions absurd, something the Supreme Court has told us we should avoid when reading statutes. I believe the interpretation of the law reflected in the Treasury rule, making tax credits available nationwide to all Americans who need them regardless of the state in which they live, accords with the plain text of the law and allows the law to work in the way that Congress intended. Interpreting Section 36B in this way allows the fundamental market reforms at the heart of the law to work in the way that they were intended, and is the best interpretation of the law when you read the law according to the way that the Supreme Court tells us we should read statutes. I'd be delighted to answer any questions the court has, and I mean the panel has. I'm used to being in front of judges, but thank you for your time, and I'd be delighted to answer further questions.
And I can promise you none of us will be wearing robes. Mr. Weiner.
Thank you, Mr. Chairman. Ranking Member Coons for inviting me to testify today. Let me say first that I think it is wrong, or at least premature, to be talking about a violation of the rule of law by the Treasury Department when the Supreme Court may yet tell us, and I think will tell us shortly, that they were right. Second, I'd like to say that the Affordable Care Act, in fact, is working. 14.1 million Americans more have insurance than they did before. The rate of uninsured Americans has dropped from 20% to 13%. Healthcare price inflation is at its lowest level in 50 years, and the rate of increase in insurance premiums has declined. Now, third, the opponents of the ACA and the King case would roll back this project, and they contend that the Treasury Department charged with implementing Congress's intent should have found that what Congress intended to do was to enact a self-destructive statute, one that coerced states to set up their own exchanges by threatening, if they did not, to impose a federal backup system that didn't work. Now, why would Congress have done that when the whole point, why would they have had a non-functional backup as a threat when the whole point of the backup was to ensure that the statute did work in those jurisdictions? And why would Congress plant a time bomb in the statute anyway? Well, the argument is that the IRS and the Treasury Department, those questions were off limits because the language was so clear that there was only one permissible interpretation. Well, let me answer one more question, and that's why would the states have an incentive without the coercion to establish exchanges? And the states themselves answered that question in the very case that Mr. Carvin handled. When they amended the complaint in the NFIB case, the state governments alleged that the exchanges were coercive. Why were they coercive? Not because they threatened subsidies of the citizens of those states if they didn't set up an exchange. They were coercive, the lawsuit said, because the states would cede regulatory authority if the federal government established exchanges. That's not my position. That is the state's position, and that is their incentive, along with a lot of grants, to establish exchanges. Now, the opponents really have to take the position that the statute has one and only one permissible reading because there is a strong presumption that you read statutes to be effective, that you read statutes in furtherance of their evident purpose. Justice Scalia says that in his book on statutory interpretation. And the argument here is that this self-immolating interpretation that the Treasury Department was so derelict in rejecting can prevail only if it is impossible to construe the statute any other way. It's crystal clear, they say, but no one at the time the statute was enacted was aware of it. In fact, it was so obscure that it wasn't discovered, and that's the word that has been used, discovered, until months after the statute was enacted by a lawyer whose announced mission was to find a statutory glitch that would take down Obamacare. Nor is this a one and only interpretation accepted now by authoritative interpreters, probably for at least four members of the Supreme Court, the Solicitor General, Senate and House leaders and staffers who were involved in the drafting of the bill, health insurers, the American Hospital Association, the American Cancer Society, 22 states, the former director of the CBO. All of these people interpret the statute the same way the IRS does. And to say that their interpretation is impermissible is to question either their literacy or their candor, and neither is really in doubt. Let me just say, with regard to the IRS and their process, truth is a defense. And the IRS engaged in a process that produced a reasonable result, one that did not gut the statute, as the interpretation offered by the ACA opponents would do, one that was consistent with the commonly understood meaning of the statute by those who enacted it at the time. Thank you.
Thank you very much. I'd like to thank each of the members of this learned panel. I agree very much with the testimony of Mr. Carvin that this is fundamentally about the rule of law. This is fundamentally about the question of whether the federal government can impose billions of dollars of taxes upon millions of Americans directly contrary to the text of federal law. It is likewise about whether the federal government can spend billions of dollars explicitly prohibited by federal law. If the answer to both of those questions is yes, if the administration's interpretation is acceded to, it makes the entire constitutional law-making function superfluous. If the executive has the authority to tax and spend directly contrary to statute, the limits on the executive's authority are altogether abrogated. Now, the legal question is not terribly complicated. The statute provides that monthly premiums for qualified health plans enrolled through an exchange established by the state. The entire argument here is whether the federal exchange established by HHS is an exchange established by the state. Now, several witnesses have testified that no one possibly envisioned that an exchange established by the state meant an exchange established by the state. I would note, we can have the second panel, please. I would note that at least one person understood that very well, someone who has been described as one of the leading architects of Obamacare, Professor Jonathan Gruber, who indeed achieved worldwide fame when he candidly admitted that passage of Obamacare depended upon, as he put it, the stupidity of the American people. And Professor Gruber quite candidly said, what's important to remember politically about this is if you're a state and you don't set up an exchange, that means your citizens don't get their tax credits. Now, I would note, we've heard several times, no one understood this. Well, apparently Professor Gruber understood it very well, but was relying upon a lack of transparency and, as he put it, the stupidity of the American people to keep it hidden. I want to focus on the decision-making process that occurred at Treasury and the IRS. Mr. Weiner mentioned that no one is questioning the candor or erudition of Treasury or the IRS. Well, it is difficult to make an assessment of that because they're unwilling to show up and defend their decision-making. So what I can tell you is they're not here. They are refusing to recognize the oversight responsibility of the Senate. So I'd like to ask you, Mr. Cannon, you have examined this question closely. What do we know about the decision-making process at the IRS and Treasury in establishing the rule here?
Well, unfortunately, very little, Senator, because as I mentioned before, a request by Senator Hatch for all the documents related to the development of this rule has been ignored by Treasury and IRS for 3.5 years. In September of 2014, the chairman of the House Oversight Committee, after being frustrated by Treasury and IRS's unwillingness to release those documents to his committee, issued a subpoena for those documents. Treasury and IRS have been ignoring that subpoena for how long ago was September of last year, almost a year.
So let me stop you on that point, because it was said a moment ago that no one is doubting the candor of Treasury or the IRS. You're telling me that Treasury and the IRS are denying a congressional subpoena, are refusing to show up to this hearing? Is that correct?
That is, well, the congressional subpoena has to do with a subpoena from a House committee for those documents, not a subpoena to show up at this hearing. But yes, they are ignoring a congressional subpoena to provide those documents, which I think bears on the suggestion made by the ranking member that if they don't show up at this hearing, perhaps compulsory process could be pursued. Compulsory process has already been pursued against Treasury and IRS.
And the Obama administration is defying that process. Well, that seems at a minimum not an exercise in candor, living within the ordinary bounds of the English language.
It's not an ideal of transparency, no.
Now, my understanding is that staff was permitted to review some documents under highly restrictive circumstances. Can you describe those circumstances as you understand them?
Well, after much persistence by the staff of the House Oversight and Government Reform Committee, the Treasury and IRS did release some documents, 387 pages, I believe, a fair amount of which was the final rule itself, about half of it, a lot of it, maybe I would think a fifth, 20% of it was my work that they just released to the committee. Only about 5% even commented on, was there any substantive discussion by Treasury and IRS officials? And it was never, here are the factors we're considering. It was just mentioning these things tangentially. As for those are the documents that they've released, which don't tell us a lot about.
But staff, as I understand it, was also
process.
allowed to review some documents, but not take notes, not make copies of those.
There are many documents that Treasury and IRS have not released, and on 2 or 3 occasions, staff were allowed to review those documents. They're allowed to go into a room sometimes with pen and paper, sometimes without pen and paper. They were not allowed to take any of those documents out of the room. They were not allowed to make copies of those documents. They were allowed to look at them and make notes. And on one occasion, they were not even allowed to make notes. They were only allowed to
no notes, no copies, no transparency to Congress, no transparency to the American people, defying subpoenas, refusing to show up at this hearing. Now, my understanding is those documents, which they are fighting tooth and nail to avoid sunshine coming upon, show that initially career staff at Treasury and the IRS analyzed the phrase an exchange established by the state and concluded that it means exactly what it says, an exchange established by one of the 50 states. Is that correct?
Well, I'm not sure about that, Senator. What we know is that, and this was from the in-camera review, where they're allowed to go into the room with the documents, but couldn't even take pen and paper with them. They had to scramble out of the room and write down everything they remembered seeing. From that in-camera review, staff were allowed to look at different drafts of the proposed rule before the proposed rule was issued. And what we know from their review of those drafts is, initially, IRS officials had included that statutory requirement that tax credit recipients be enrolled, quote, through an exchange established by the state. Around the same time a Treasury official raised this issue with the IRS, that requirement, that statutory language, was dropped from the proposed rule.
So, Mr. Cannon, I want to make sure this committee understands that. Our understanding, although to be clear, the Obama administration is blocking release of the documents, so it is all deliberately hidden in the lack of transparency that Professor Gruber bragged about. But our understanding is the initial version of the rule drafted by career staff at the IRS and Treasury attempting to follow the law followed the plain text and concluded it had to be an exchange established by a state. But then subsequently it appears that political appointees at the Department of Treasury overruled that decision and substituted instead a political decision contrary to the judgment of the career staff, but consistent with the political outcome desired by President Obama and the White House.
What we know for a fact is that that provision, that statutory provision, was dropped from the implementing regulations around the same time that this political appointee at the Treasury Department intervened. We don't know anything of the substance of those discussions, what happened there, but we do know that that was a statutory provision that was on its way to being implemented as part of the proposed rule, and then it was dropped. And that's significant because that tells us a couple of things. One, it tells us that Treasury and IRS officials never believed that the phrase, the statutory requirement, through an exchange established by the state, was a term of art, as the Solicitor General now argues.
And my understanding is at least some of these documents had notations, initials, that appear to reflect an individual, or perhaps may reflect an individual who also worked in the White House as part of the policymaking apparatus. Is that correct? Although this is all murky and opaque by design of the administration. But is that your understanding as well?
There was White House input into the development of this rule, as there was White House input into the development of many rules. We don't know exactly who provided that input.
But the initials LF were written on at least one of these documents?
I have not reviewed those documents, but that is what House investigators report.
All right, let me ask a final question. The administration is arguing, pursuant to Chevron deference, that it is the courts owe deference to its efforts to implement this law. I want to ask Mr. Carvin, if the process that there appears to be a suggestion occurred here, although quite deliberately the administration is blocking any effort for the American people to know if it occurred, but if it is the case that career professionals at Treasury and the IRS, in their expert judgment, read the statute to mean exactly what it means on its face, that an exchange established by the state means an exchange established by the state, and if it is the case that political operatives ordered those career professionals to disregard the law and reach a political conclusion instead, is it your understanding that that sort of partisan political decision to disregard the law is the kind of decision that is ordinarily given Chevron deference?
No, Mr. Chairman, as you know, one of the principal things that agencies can't do under Chevron is behave in an arbitrary and capricious manner, and obviously the paradigmatic definition of arbitrary and capricious is simply implementing political or ideological objectives. I'd also point out in terms of process, you're not deferring to the tax expertise of the IRS as if the task force, which I think is undisputed, drawing up these regs was not just IRS people, it was HHS and White House operatives. So I don't even think they went through the pretense of pretending this was a neutral interpretation of the law. I hasten to add, of course, Chevron's inapplicable here anyway because the statute is completely unambiguous, so there's no opportunity for deference. And as Justice Kennedy pointed out during oral argument, there's a strong canon of statutory construction that because this body, Congress, controls the purse, monies will come out of the federal treasury only if that's done unambiguously.
Thank you, Mr. Carbon. And I would note that if it is indeed the case that partisan political operatives in the Obama administration instructed career professionals to disregard the law and reach a political outcome, it's not surprising that they were afraid to come here and testify and explain that that's what occurs, and that perhaps gives some context to why the three witnesses in the first panel chose not to attend. Senator Cruz.
Thank you, Mr. Chairman. I'll note you've taken nearly 10 minutes, and your first question, I hope I'll have roughly the same period of time if possible. I believe the core issue we are seeking to have a conversation about here today is the availability of subsidies, their role in the ACA, and the appropriateness of how the ACA has been interpreted and applied. So let me first speak more broadly to that general context. The ACA, as Mr. Weiner pointed out in his testimony, is working. Thanks to the ACA, 16 million people have gained access to affordable quality health insurance, and since October 2013, the uninsured rate, just to take one of many positive statistics, for the non-elderly adults in America has fallen by nearly 35%. This success would not be possible without the availability of the premium tax credit, which provides nearly 8 million American individuals in the 37 states using healthcare.gov with an average subsidy of $3,200 to purchase health insurance. As we all know, this historic decrease in the number of uninsured is only possible under the ACA. It is only possible that it becomes affordable because the 87% of individuals who signed up under healthcare.gov qualify for subsidies, and this was central to the intent of the law. In my view, eliminating subsidies, which may well be the outcome of Supreme Court action if they, I think, rule on this in a way that is advocated by some today, would result in a massive disruption in the individual market, with millions losing access to affordable insurance and average costs of the remaining insured increasing significantly. It is my contention that that is not required by the structure, the text, the history of the law. In fact, the opposite, that the text and the history and the structure of the ACA leads to only one possible conclusion, that tax credits are available to all poor, working class, and middle class Americans, those who earn between 100 and 400% of the poverty level. As we all know, there are many who have opposed the ACA for principally ideological reasons. They fought it in Congress and lost. They fought it before the Treasury Department and lost. They fought the individual mandate in the courts and have lost. Now another group of opponents has raised another legal challenge, asking our courts to bless a contorted reading of the law in a way that would sabotage a core provision of the Act and undo the way that these subsidies work to the fulfillment of the core goal of the Affordable Care Act. Now, neither the distinguished chairman of the subcommittee nor myself were present as the law was crafted, but there have been a number of quotes in the press recently from those who were actively engaged, suggesting that this cramped reading that's being advanced runs directly contrary to the universally held understanding of those who were engaged in its drafting and its implementation, from Doug Elmendorf, head of the CBO at the time, to members of the Joint Committee of Taxation, to Charles Clapton, a former counselor to Senator Enzi, to Senator Snowe herself, who've all recently been quoted saying that they did not see or recall any distinction between federal and state exchanges as this was being drafted, and the denial of subsidies based on that would have gone contrary to their understanding of the intent. So let's be clear. In my view, this hearing is just another part of a 5-year effort to deny working class Americans any help in affording health insurance. Having failed at frontal assaults, the ACA's opponents are trying to contort the letter of the law, this important law, to defeat its spirit. And so for some insight into that, let me begin with Mr. Weiner, if I might. In your view, is there any doubt that at the time the ACA was adopted, it was understood to mean what Treasury has subsequently said it meant at the time that it was passed? And what, in your view, happened to create the dispute that we're discussing today?
Senator, there's no doubt at all of that proposition. We see, for example, Jonathan Gruber's statement several years after the statute was adopted. He's an economist, an academic economist. Well, I see your Jonathan Gruber, and I raise it with 4 aces. Senator Orrin Hatch, who said back in January 2010 that establishing an exchange is not a condition of receiving federal funds. And that was stated by other people as well. In June, well, I mentioned when the states amended their complaint. October 2011, the American Legislative Council, Exchange Council, ALEC, a right-wing organization, told the states, in urging them not to adopt exchanges, there's no penalty for a state in allowing the federal government to implement an exchange. November 2012, Nebraska's governor, explaining why the state wouldn't set up an exchange, said there's no real operational difference between a federal exchange and a state exchange. Officials assessing exchanges in Georgia, South Carolina, West Virginia, all these states evinced a knowledge that subsidies were available. This is the way the statute was understood. And since it was understood that way, it really doesn't prove much to say that the Treasury Department incorporated the language of the statute into an early draft of the regulation.
Thank you, Mr. Weiner. If I might, Ms. Wydrop, the majority witnesses have urged us to read 4 words in isolation and have argued that it leads to only one possible interpretation. The Supreme Court, in its 2007 decision, National Association of Home Builders versus Defenders of Wildlife, wrote, quote, "The meaning or ambiguity of certain words or phrases may only become evidence when placed in context." How does the context of these 4 words, how does the text of the entire statute support the reading that exchanges established by the state includes exchanges established for the state by the Secretary of HHS? You touched on this in your previous testimony. I'd appreciate you revisiting the point.
Thank you, Senator. Yes, the Supreme Court has made absolutely clear in numerous court rulings by justices of all ideological stripes that statutes are to be read in their entirety, in their context, and to effectuate rather than to defeat their central purpose. And I think it's important to note that there are basically 3 main features of the Affordable Care Act that make its insurance market reforms work. You have the individual mandate, which ensures that either you sign up for health insurance or pay a tax penalty, assuming you have the income to do so. The important market reforms, such as preventing insurance companies from discriminating against individuals with pre-existing conditions. And then, of course, you have what we're talking about here today, which are the tax credits, which make it affordable for Americans to enter the insurance market and to make the entire Affordable Care Act's reforms work as they are intended to by the law. So in looking at the statute as a whole and in looking at the issue that is before the Supreme Court in King v. Burwell, it's important to note the role of the tax credits in effectuating the key purpose of the Affordable Care Act to make insurance available for all Americans. And so I think when we're looking at the exchanges, it's important to note that when you're talking about who is going to run the exchange, whether or not the state establishes its own exchange or the federal government does it according to Section 1321, standing in the shoes of the state, the idea is still to ensure that tax credits are nationwidely available to all Americans who need them. Otherwise, the act simply doesn't work, and numerous provisions of the law are rendered absurd if you take the reading of the tax credit provision that critics of the Treasury rule have put forth. We talk about what Congress intended, and when you look at what they intended, it was, again, because of the purpose of the act and the way that it is structured, integral to achieving the purposes of the law that every American who needs these tax credits be able to have them. That is the way that it was scored by the Congressional Budget Office, the statute. That's the way that the Joint Committee on Taxation understood the law to work. That is the clear congressional intent behind the law. And so when you look at the law in the way that the Supreme Court tells us, looking at it in context, reading the text of the law, looking against the backdrop of cooperative federalism, which Justice Kennedy raised in oral argument, noting that if you take the critics of the Treasury Department's rule, you could basically put the states to an irrational choice, either set up an exchange, or if you take the federal fallback, which the statute allows you to do, we will take away millions, perhaps even billions of dollars from your constituents who need them, need those tax credits desperately. That just simply doesn't make sense, and it's not in line with the way the Supreme Court tells us that we should read statutes.
Thank you, Ms. Weidner. That's very helpful. I appreciate the testimony of both witnesses.
Thank you. Senator Sessions.
Thank you, Mr. Chairman. Well, the fact that you say there's a goal to make insurance available for all Americans doesn't mean the statute can be written to, in any way you'd like to effectuate some theory of care. Congress will be faced with the legislative responsibility, if the court rules, to deal with the statute as it is left standing. It's going to be a difficult challenge, but I think that's what we're paid to do. The president doesn't get to make up the law as he's done so often. It's really troubling to me, the extent to which this has become the theory around here, that the executive office must do something. Congress will fail to act. But when Congress fails to act, it acts. It makes a decision. It says no to some of these things. They didn't pass the law unless the state exchange language was in there. That's what Congress passed. So I really think we're in dangerous ground when we get this far away from plain statutory law. With regard to the health care cost, I see in CNN Money, a recent report from CNN Money, United Healthcare cost in Florida is up 18%, Humana up 30% in Texas. That's two of the biggest states and two of the biggest insurers in America. I don't know how well it's doing in the practical world. Now, Mr. Grewal, let's take another area that I think is even simpler that you raised in your study, that the Affordable Care Act provides tax credits to U.S. citizens with incomes between 100 and 400% of the federal poverty level. Are you aware of anything else in the Affordable Care Act that would alter that number, that range, 100 to 400?
No, it's for aliens, there's an exception. Congress decided that for aliens, they would come up with a special rule because aliens could not get Medicaid. But for citizens, there's absolutely no statutory exception, and the IRS has affected that amendment by regulation.
And so by regulation, IRS altered that what would appear to be plain language to extend credits for citizens that would affect several million people below 100% of federal poverty level. Is that right?
Yeah, right now the estimate by Kaiser is about 4 million people aren't eligible for Medicaid, but don't satisfy the 100% statutory floor. So we're talking several million people, yes.
And Mr. Carvin, you've studied this. Are you aware of any exception that could be used to justify adding several million people when they don't fall within the statutory range?
It's precisely the rationale they use for the lawless IRS rule here, which is it's a good thing to give poor people insurance. Congress cut it off below 100%. We don't like that, so we're going to take billions of dollars from the federal treasury and help poor people. We don't need no statutory language. We'll just do what's right. And so, no, it's precisely the same analysis you've seen here, which is this supposed to be available for all Americans, and therefore we can do whatever we want.
Mr. Grewal, another one, it seems to me, is dramatically clear and has been violated. As you noted, Section 36B of the ACA grants credits to some non-citizens with low incomes only if they themselves are lawfully present in the United States and cannot obtain Medicaid coverage. IRS regulations issued pursuant to that statute, however, contradict the statute and allow subsidies if, quote, the taxpayer or a member of the taxpayer's family is lawfully present in the United States. And, quote, the lawfully present taxpayer or family member is not eligible for the Medicaid program. Do you find any statutory basis for the administration to find such an exception to what appears to be plain language?
Absolutely not. And the odd thing about that particular change is, as opposed to the other two, at least for the other two, they have the courtesy to announce what they were doing in the preamble to the regulation. For this one, there's no explanation at all, just the text of the regulation goes beyond the statute without any hint that they're expanding the credit to persons not lawfully residing here.
Well, I think your analysis is important to us. We've had a number of studies that talk about really a lawless approach to governmental administration. And the American people have a right to expect that when a law is passed, the chief executive will follow that law. And this is just plain. Mr. Carvin, you studied the ACA. Is Mr. Grewal correct? Is there any authority that you can find that would allow the administration to provide health care coverage to individuals if they're a member of their family is lawfully present in the United States?
It's yet another revision in a series of stark revisions to the ACA that the Obama administration has done, all pursuant to roughly the same analogy, which is we want to make this better, we want to make it work in the way that we want, and all the kinds of legislative compromises that go into actually crafting statutes will be disregarded if the people in the administration view it as inconvenient.
Well, I think maybe, Ms. Wider, the statute could have just been written. Our goal is to make available health care for all Americans. That wasn't what the law said, however. Thank you, Mr. Chairman.
Thank you, Senator Sessions. Senator Blumenthal.
Thank you, Mr. Chairman. Mr. Carvin, you argued in the Supreme Court, did you not?
I did.
You argued for the plaintiffs?
Correct.
Are they here today?
No.
You know, this hearing has been conducted with a lot of hype and hyperbole, not uncharacteristic of the debate surrounding the Affordable Care Act, a lot of overheated, overreaching rhetoric, but there are some facts. And as Ronald Reagan said, facts are stubborn things. The fact is, the Affordable Care Act is working. It has provided insurance coverage to millions of Americans, more than 10 million Americans. And not only did Congress intend certain results, but what Congress intended is actually happening. We're dealing here with reality on the ground. In Connecticut, which has a health exchange, like 13 states do, the uninsured rate has been cut by 1/2, from 12.3% to 6%. 7.7% of Connecticut consumers have qualified for the tax credit. Millions of people across the country are now protected against discrimination, for example, based on pre-existing conditions. For years and years, as the Attorney General of the state of Connecticut, I did advocacy on behalf of people who were discriminated against because of supposed pre-existing conditions. There's mental health care that has been expanded, along with substance use disorder benefits and federal parity protection. 62 million Americans have benefited, and more than 600,000 in Connecticut. So the ACA is working. And the Public Health and Prevention Fund has provided Connecticut alone with $31 million for tobacco cessation, obesity prevention, health coverage, enrollment assistance. Those facts, in effect, I think, support the argument that Congress not only intended certain consequences, and the interpretation suggested by Ms. Wydra and Mr. Weiner fits as part of the statutory whole and the context of the statute, but also the results of the statute. I'd like to ask Mr. Weiner whether that interpretation, in effect, of the statutes, the reality on the ground, comports with what Congress intended.
Yes, it very much comports with what Congress intended. Congress did say in the statute that the goal was to extend health care, affordable health care, to all Americans. It said it 6 times. That was in language that was enacted by Congress, not some purpose intuited by a judge. It was what Congress said it was trying to achieve in the statute.
Ms. Widener, do you agree?
Yes, absolutely. Senator Sessions joked that the statute should have been written to say health care should be available for all Americans. Well, point of fact, Title I of the Act is titled, quote, quality, affordable health care for all Americans. So that is the stated purpose of the law, and it wouldn't make any sense for Congress to have written the tax credit eligibility to defeat that purpose.
And Mr. Carvin, I assume you disagree.
The model that was followed in the ACA for the subsidies was precisely the model for Medicaid. We all agree that Medicaid was conditioned on the states doing certain things. My friends on the left here would say it would be insane to end Medicaid payments for the neediest Americans, and yet the ACA conditioned the Medicaid on the states doing certain things. And that's because this body thought we can get the best of both worlds. We can get the states to do something, and we can get universal coverage. Precisely the same logic obtains here. You give the states a real incentive to do things, and then the premiums will flow if the state does it. So there's 2 purposes to the ACA. One is stated in 1311, states shall run exchanges. The second is we want subsidies to be available. The only way to accomplish both purposes is to condition the subsidies on states running the exchanges, just like Congress conditioned Medicaid funds on the states altering their Medicaid eligibility standards. So there's nothing inconsistent with the purpose. There's nothing illogical, unless this body is going to say that it was utterly illogical to do with it what it did with Medicaid. So no, it's perfectly logical, perfectly reasonable public policy.
Well, let me just say that your friends, who from your perspective are on your left, actually are on our right.
I was giving a geographic description, not an ideological one.
Which I think, in a sense, reflects the different perspectives that we may bring to these issues, and I respect yours. But I would just suggest, again, that Congress established a system that fits together as a whole. It's working as a whole. We can argue hypothetically, we can use rhetoric, but the fact of the matter is Congress actually did something good here. I can say that because I wasn't a part of Congress at the time, and I approached this area with a lot of humility. Very simply, in my view, a ruling for the plaintiffs in King v. Burwell would be contrary to law, would be catastrophic for millions of families who owe their health insurance to the statutory structure that Congress approved. Not a perfect structure, not absolutely perfect in all of its wording and statutory language, but a ruling for the plaintiffs, in my view, would be a human tragedy, as well as a legal travesty. And so I'm hopeful that the reasoning that you advance to the court will not succeed. But I thank you for being here today, and I thank all of the members of the panel. Thank you.
Thank you very much. I would note on the discussions of the expansions of health care that studies have also shown that virtually all of the expansion has been on Medicaid, and that roughly 900,000 people have received private insurance, that nearly as many people have had their insurance canceled as have signed up on the exchanges for private insurance. And the data are compelling that forcing people onto Medicaid ends up predictably producing worse health care outcomes. With that, Senator Hatch.
Well, I might also add that more people are now going to the emergency rooms because they can't get care. It's too long a wait to get the care that they need. I also want to bring out that there were about 30 million people that didn't have health care when we started this issue and this bill. Guess how many there are today? Between 30 and 35 million still don't have health care. Now, maybe you can make some explanations about that. You quoted my letter, Mr. Weiner. I'll just put the letter in the record if I can.
Without objection.
Also, Mr. Corman, well, let me just say another thing to Mr. Weiner. With respect to Mr. Weiner, the quote that you made from my law review article, where you said supports the president's position, was a reference to a Supreme Court's holding in South Dakota versus Dole. Now, I do address that issue in my UCLA law review article, and let me just put that into the record as well, just the page where I address it. Okay?
Without objection.
Mr. Corman, you've been carrying a lot of load on your shoulders here. Proponents of the president's position have argued that Congress could not have intended to deny subsidies to federally established exchanges. But isn't it a fact that a very good reason that Congress would have wanted to limit subsidies to state-established exchanges was namely to incentivize states to create these exchanges? And Congress couldn't order the states to create exchanges directly, so it needed a way to incentivize the states to create exchanges. I think, isn't that a perfectly reasonable argument as to what was going on here?
You're entirely right about the constitutional provision. This body has, in countless statutes, incentivized states precisely the same way. It's noteworthy that the Help Committee, at the same time that was considering it, conditioned subsidies on certain insurance reform provisions. The Clinton administration health care proposals also conditioned subsidies on state cooperation. So far from departing from the norm, this is the norm that this body has continually used, not only in the healthcare area, not only with respect to Medicaid in the ACA, but with respect to virtually every provision, which is, since we can't force the states to do it, but we wanted them to take an operational role, the best and traditional way of doing it is conditioning federal funds on having the states become our cooperative partners.
All right, well, let me just say, ask this question to you and Mr. Cannon as well. I want to thank you both for your important work on this issue. I'd like to read for you a passage from my recent UCLA law review article and then ask you to comment. Quote, advocates of the president's position that Obamacare authorizes subsidies for federally enrolled plans would have us believe that statutes are infinitely malleable. Up can mean down, right can mean left, established by a state can mean established by the federal government. What matters to them is advancing some alleged statutory purpose, regardless of what the statute actually says. Now, that furthers the president's agenda. Now, those of us on the other side, however, insist that text does matter. Words matter. They always have. And what the statute says is what matters, because at the end of the day, the words in our statutes and in our Constitution are what bind our leaders and what prevent them from doing whatever they want to. Now, fidelity to text is the foundation of the rule of law. Do you agree with that passage?
I do, and I want to make it clear that we're not talking about ripping text out of context. I fully agree with my friends that you need to read this in context. I have said that approximately 400,000 times, and I've always supplemented it with the point that context reinforces, for the reasons I've already articulated, at every turn that 36B should be interpreted to mean what it says. So we're not talking about some green eye shade, pulling words out of context. That's not statutory interpretation. Read in context, this serves a very valuable, sensible purpose, and there is no reason to depart from the plain language.
Mr. Cannon, in your written testimony, you discussed an investigation that 2 House committees conducted into the IRS's drafting of the Obamacare subsidy rule. Now, what are your takeaways from that investigation? And just, if you could add this too, in your view, what are the most troubling things that the House investigators found?
Well, as I mentioned in my testimony, I think the most troubling things are those that show or that indicate that the Treasury Department and the IRS recognized that this statutory language posed an obstacle to how they wanted to implement the statute. So they jettisoned what the statute says and they implemented the law as they saw fit, or they just exercised power as they saw fit. And this is not a victimless sort of scenario here. There are 57 million individuals and employers in this country who are being subjected to illegal taxes because the IRS decided that it would ignore the clear language of federal law. One of those people is Kevin Pace, who I mentioned in my testimony. His income, he took a hit to his income of $8,000. He's a jazz musician. If you think $8,000 is a lot of money to you, it's a lot more money to a jazz musician. Others who are affected by this rule are seeing their incomes hit by $1,000. Others are paying penalties to the IRS, employers and individuals, from which they're statutorily exempt. That is, and the IRS, it appears from what little we know, that the IRS knew that this language prevented them from doing that, but they tried to find a workaround. They tried to disregard it. The other problem, or the other thing that this investigation shows is how the arguments that the government has made before the Supreme Court were not the reasoning that the IRS used when it developed this rule. The fact that they jettisoned the statutory phrase "through an exchange established by the state" from their implementing regulations tells us that they knew it was not the term of art the Solicitor General claims. If it were a term of art that incorporated an exchange established by the federal government, there would be no reason to take it out of the the draft proposed regulations. You could keep it in there if it's a term of art, but they knew it was not. They knew it was an obstacle to implementing these taxes and spending that money, and so they threw it out.
Mr. Carman, let me just ask you this. Under the well-known Chevron doctrine, if the statute is ambiguous, an agency interpretation can be sustained only if it is a product of, quote, reasoned decision-making, unquote. From the evidence we have, do you believe that the IRS subsidy rule was the product of reasoned decision-making? And if not, why not? And what does that tell us about the lawfulness of the rule?
As I indicated,
you can also answer, if you care to, the arguments of our two who are arguing for the administration's position.
well, with respect to your specific question, Senator Hatch, no. As I've indicated to Senator Cruz, fulfilling in the administration's ideological agenda is the opposite of reasoned decision-making, because they're simply substituting their policies for that of the enacted law. And I would, in addition, point out that it strikes me as incredible, and I believe the Solicitor General more or less admitted this during oral argument, that from anybody's perspective, the notion that this body was delegating to the IRS the seminal decision on whether or not to have these subsidies, which my friends to the left agree is very important to the act, strikes me as quite counterintuitive. This was not filling in the gaps in a statute. This was the basic policy decision. So no, Congress spoke precisely to the question at issue, as the Chevron phrase has it. Congress made a decision, so there was no room for the IRS, much less White House operatives, to change the basic policy decision embodied in the statute.
Well, thank you. Now, let me ask Professor Andy, is it Graywall?
Graywall, yes.
Graywall? Okay. I want to pronounce it right. I hope I'm pronouncing yours right. Is it Weiner? Yes. That's okay. Now, you identify in your written testimony several other IRS regulations that grant Obamacare subsidies to statutorily ineligible recipients. These include regulations granting subsidies to individuals outside this statutory income range, individuals automatically enrolled in employer health care plans, and even some categories of unlawful aliens. Now, what does the fact that the IRS ignored limits on its authority to grant subsidies in other instances tell you about its general attitude toward obeying limits on statutory authority?
Regarding the King v. Burwell issue, if that regulation is valid, it's impossible to believe that it's because they closely paid attention to the statute and their statutory authority. It could be by accident that the regulation is valid, but I think with so many instances, it's obvious to me that they are implementing the law that they wanted to see enacted rather than what actually was enacted.
All right, well, I think I appreciate the extra time that the chairman and ranking member have granted to me. I appreciate you both.
Well, thank you, Senator Hatch. I'd like to thank each of the witnesses here. We have heard, I believe, incredibly important testimony. Testimony that I think has particular salience to the millions of residents in the states that have not established state exchanges, to the millions of young people fresh out of college, millennials, who the Obama administration is trying to exact billions of dollars in illegal taxes from each of you. To legal immigrant like my father 58 years ago. If you live in a state that has not established an exchange, the testimony we've heard today at this hearing is that the Obama administration is trying to impose on you personally thousands of dollars in penalties that are flatly contrary to law. And I would note that these penalties coming from the individual mandate disproportionately hurt the most vulnerable among us. The people being hurt by these illegal taxes are not the Warren Buffetts and Bill Gates of the world. They're young people, they're single moms, they're Hispanics, they're African Americans that are suddenly finding a big tax bill that is due from an administration that is ignoring and violating federal law to extract illegal taxes. And I would note the testimony this panel has given that the career professionals at the IRS and the Treasury Department recognized they were bound by law not to collect those taxes from millions of people who didn't owe them until political operatives, the testimony suggests, overruled them, instructed them to disregard the law and collect taxes from people who did not owe them and could not afford them. That testimony is quite stunning, and it is testimony that every American ought to consider. I want to thank each of the witnesses from this subcommittee, and the committee will keep the hearing record open for an additional 5 business days, which means the record will be closed as of the close of business next Thursday, June 11th, 2015. I note Senator Cruz wishes to make a closing remark, so I'll allow Senator Cruz.
Thank you, Mr. Chairman. We came to this hearing today with differing views of the history, the structure, the purpose, and the impact of the ACA. And I thank the witnesses for their testimony, but I think we leave with sharply differing views of the path forward and of what the purpose was of this hearing today. In my view, this is just another part of a 5-year-long effort to deny working-class Americans any help in affording health insurance. Having failed at repeated frontal assaults, the ACA's opponents are now trying to advance a contorted view of the letter of this important law in order to defeat its very spirit. And I, too, will raise the specter of a tax increase. These opponents of the Affordable Care Act apparently find the idea that every American should have access to affordable health insurance so offensive that they are willing to advance a cause which, if successful, would immediately raise taxes for 7.7 million Americans by an average of $3,200 a year in order to destabilize this law and ultimately in an effort to bring it down. I hope they are not successful, and I hope instead the Affordable Care Act continues to be improved and to strengthen access to quality health care in this country. Thank you for holding this hearing, and I appreciate the fairness with which you've conducted it.
I thank the members of the panel, and the hearing is now adjourned.